Can you be arrested and charged with possession of drugs or possession of a firearm, possession of a gun, if you don't have anything on you? So the answer is coming right up. We'll get that to you. My name is Marcy Fosio. I'm an attorney at Fosio Law, a criminal defense firm specializing in helping people who have been arrested or charged with a crime in central Oklahoma. So, can you? It's happened before. We've certainly had the situation where someone gets charged with possession of drugs or possession of a firearm, possession of something when they had nothing on their person. How does that work? Unfortunately, there is something called constructive possession. And what that means is even if you don't have something on you, like say I don't have any drugs in my pockets, I don't have any drugs in my purse, no drugs, no gun on my person, but based on where it's located, I'm charged based on the principle of constructive possession. What constructive possession means is basically the knowledge of that it exists and the ability to control it. Ability to control it basically just means I could go in there and get it. I know where it's at, I could pick it up, I could do something with it. As an example, there's a gun in your house, in a closet, hidden underneath your dirty socks. So it's not on your person, but it is in your closet under your dirty socks. So you could be charged with possession of a firearm even though you don't have it on your person because of constructive possession. And also, let me kind of point out when I'm saying possession of a firearm in and of itself is not a crime. We live in Oklahoma, tons of people have guns. So possession of a firearm is only a crime in certain situations. For example, if you have a prior felony conviction, then you're not allowed to have a gun. So sometimes we'll see the charge possession of a firearm after former conviction of a felony. So just know that when I say possession of a firearm for shorthand, I'm talking about if you have a gun and you're not in a situation where you're not supposed to have one. Same thing about drugs. This happens kind of frequently. Say two people are driving in the car. Say I'm driving the car and somebody sitting over here has drugs. Where at? Is it in their pocket? Is it under their seat? So I don't have any on my person, but can I be charged with these drugs? So to be charged with it, the state, the prosecution, the cops, they're gonna have to have evidence that you have constructive possessions. Actual possession means it's in my hand, it's in my pocket, it's in my purse that I'm holding, I clearly have it, actual possession. Or constructive possession is when I don't have it, but I have the ability to control it. I know about it, I can go get it if I want to. So back to my situation where I'm driving, I don't have actual possession. It's not sitting in my lap, it's not in my pocket, I don't have it. But the question is going to be, can the police, can the prosecution prove that I have constructive possession? Can they prove through circumstantial evidence that I knew the drugs were there or that I had the ability to control them? And it's gonna be a case-by-case situation. There's not a yes or no answer. Everyone, the lawyers, the jury, the judge, whoever's involved is going to look to the totality of the circumstances to determine is there evidence to show that you have constructive possession. If it's out and obvious, say there are a bunch of drugs right there on the floorboard and it's obvious, they're probably going to say I have constructive possession because I can't say I didn't know about it. On the other hand, if we're talking about like one pill that I don't have a prescription for, and it's in this guy's pocket, my passenger's pocket, I've got a pretty good argument that I didn't know about that one pill, that I didn't have the ability to control it, and that I did not have constructive possession. To be charged with possession of a firearm, or possession of CDS, or possession of some illegal thing, they've got to show possession. But the distinction here is actual possession or constructive possession. So if they can prove that you actually possessed it or that you had constructive possession, then they can charge you with a crime. If they can't prove, or if there's insufficient evidence that you possessed it, either actually or constructively, then they can't charge you. Or better yet, they shouldn't charge you. Sometimes, of course, the state or the prosecution might overreach. In other words, they might try to take the position that they have evidence that you have constructive possession. Well, that's where a good lawyer comes in. If it's really weak, the evidence that they have, like one pill in your passenger's pocket, that's where you want a good lawyer to be able to come in and say, no, that's not enough evidence. That's not sufficient evidence to charge my client with constructive possession. 5 pounds of marijuana, they're probably gonna have enough to show constructive possession if it's right there in plain view. Or if you've got a gun in a duffel bag right next to your wallet with your ID on it, that's probably enough to show constructive possession. But one pill in your buddy's pocket, probably not. So as I said, there's a lot of gray area. It's definitely a case by case, but we're gonna look at the totality of the circumstances and see if there's enough evidence to actually hold you to those charges. And like I said, that's where a good lawyer comes in. We're not going to let them say you possessed it just because they said so. We're gonna make sure they've got the evidence and the facts to back it up. So that's kind of the things that are gonna come into play. If they don't have the evidence to actually prove it, that's not gonna fly. If you have any questions about possession or firearms or drugs or anything like that, then give us a call and figure out what we need to do next, what's next, and kind of walk you through that. So give us a call.